Well, welcome back to the Law&Crime Network. My name is Bob Bianchi, and we have a lot for you. I've been gone for a couple of weeks, took a little vacation, went on a convention, but I got some great guests. I love about her, in addition to being an awesome lawyer that does some great work with family and kids, she was a journalist and actually a TV reporter. She had the fame and distinction of interviewing the famous Stephen Avery from the Making a Murderer fame, and her jailhouse interviews of him actually required her to be summoned to testify in that case. Jennifer, welcome back to the show.
Good to be here, Bob. Thanks for having me.
My pleasure. And my man Imran Ansari from Adela, Bertuna, and Caymans?
Idala, Bertuna, and Caymans.
Caymans,
yep.
You can say it better than I. Former assistant district attorney in Kings County who's had hundreds of cases, does a tremendous amount of personal injury, civil rights, a prolific litigator on both sides of the question. It's great to have you back.
Thanks for having me, Bob.
Yeah. So listen, guys, let's get to the techniques, because I know our audience who are avid true crime followers, those of us that are the law students that are looking, or trial lawyers just looking to improve their skills. When I've taught hundreds and hundreds of prosecutors, I told them to watch out about the rebuttals. Watch out for redirect. You may have done a great job. The defense may have not done anything to score any points. So it's got to be tight, it's got to be specific, and it's got to be meaningful. Imran, what do you think? I think he did a good job on all those counts.
I agree, Bob. He definitely has a forceful presence in that courtroom, a command of the case. These prosecutors have been living with this case for the past few weeks and the prep before that. And he's really hitting home what distinguishes the attempted first-degree murder charge that the jury is considering from the manslaughter charge. And he's honing in on those 10 seconds, which is essentially arguing that the jury could find for the attempted murder charge.
Yeah, and Jennifer, what I really liked, which is another thing that I used to train my lawyers on, I'm curious about both of your opinions about this. In the end, law is not 2 + 2 = 4. It's about common sense. It's about your gut instincts. And he really drove that point home when he eviscerated their expert by saying you don't need to spend $25,000 for an expert to come on here, which is something that is simply a matter of common sense and your gut instincts, is what he was saying. I think those things resonate with jurors more than the fancy experts do. What do you think?
Yeah, I love that. I love how he said you can't perception distortion your way out of this. We have a name for this, folks. It's called lying. So I love how he came out swinging. He had this tone of outrage. How dare the defense say that this was an accident, that this was a series of unfortunate incidents that led to this. I love how he said, use your common sense. This officer provoked this person into using force. And under the law, you can't say, well, they made me do it and blame the victim. That in itself is being reckless, which amounts to manslaughter.
Right. And to Jennifer's point, Imran, you know, when we're trained in use of force, what most people probably don't get is that your uniform and your badge and your command presence and your weapon before you do anything is a sign of use of force. And so this idea that you don't have time to go out and put your vest on, or get your weapon, or get your badge rather, have enough time to have his weapon certainly, is for the protection of the officer, because it establishes a command presence, and it's also a protection for an innocent person who may not know that this person is a police officer. That was one of the common sense points he was driving home, and I think it resonated.
I agree. And the common sense argument or suggestion to the jury, I love that. When I'm on trial, even at jury selection, I set that up. I'm going to say, listen, ladies and gentlemen, you're going to have to use your common sense. You're going to hear a lot of evidence, maybe experts, but ultimately it's the instinct, the interactions you have every day with people, your common sense, which is going to guide you through this case. And the prosecutor honed in on that, and exactly what you state, Bob. All the facts here that we have in this case show Nouman Raja coming to that scene without identifying himself as a police officer, with a regular T-shirt on, a baseball cap, and aggressive movements. And the prosecutor honed in on that in his summation right now, the aggressive actions of Nouman Raja when he appeared on that scene, and failed to identify himself as a police officer.
Yeah, and guys, listen, I don't know how you feel about this, but in our world, when you've done this long enough and you've seen enough police-related fatality cases, The fact is, whether you like it or you don't like it, we're talking jury psychology here. Cops are very hard to convict. And a lot of times it comes down to whether the victim was up to no good or was actually an innocent person. Here's a completely innocent guy. That's not going to be good for the defendant, the police officer in the case. And what I also liked about what the prosecutor did was he tied common sense, 10 seconds is the most important thing, truth matters, all these concepts that resonate with the jury. But the way he then framed it all together was that this wasn't an appropriate law enforcement action. This is what we call hunting. Man, that's powerful stuff.
Really powerful stuff. And the way he delivered that to the jury, you know, it chills up my spine listening to it, and we're watching it on television. So I would imagine that was a very powerful moment that jury listened to. And also the first prosecutor we heard from on the initial summation for the prosecution this morning, she likewise was very powerful. So we see two different kind of styles here between the defense, which was more subdued and analytical, versus the more emotional way that the prosecution is delivering their summation, which you often find with prosecutors.
Right. So, Jennifer, I mean, going to a defense tactic here, if you're a defense lawyer and you have to represent an individual under these circumstances, you got a problem with the 10 seconds. You got a problem with where the weapon was. You got a problem with this victim was up to doing nothing wrong. You got a recording to the call that was made to AT&T. You got a lot of bad factual evidence against you. And so what do they say when the facts are against you? Where do you go? Arguing the law, right?
Oh, yeah, absolutely. Absolutely. So, and this defense counsel spent a significant time, especially at the end, just talking about the concept of reasonable doubt. I mean, that's what this all turns on. He just has to raise some reasonable doubt, and that's the only thing that's going to help with these 6 jurors here. And then that's effectively what he focused on there.
Let me go back to a kind of a question I didn't get a complete answer to. My fault, my bad. If this guy were a character of a nefarious background, if he were in that area for no good, but the facts were exactly the same, he didn't have a right to be shot, do you think the defense has a better argument in front of the jury from a visceral standpoint? That's been my experience. That's true. What do you think?
I don't think it changes the law.
Doesn't change the law.
Right, exactly.
Right.
So, for the argument's sake, in front of the jury, if it was established that he was there, stolen car, and I think we had that when he's calling it into the base, and we find out that it's not a stolen car, there's almost like a sound of disappointment on that officer's voice. If he was there for a nefarious purpose, I think it would be an easier argument for the defense to make that the actions of Nouman Raza were justified. But we don't have that here. So. If it was there, it would definitely be hit on by the defense. But ultimately, you have someone who is innocently at the side of the road with a broken down vehicle gunned down by an officer.
Right, sure. That's definitely what we have in this case. Jennifer, do you think, though, it would make a difference if you had a person who was shot by the police officer under these circumstances that had or was up to no good when they were there and had a nefarious background, although that clearly are not the facts of the case here? Could it change a jury's mind?
Right. I think it could change the jury's mind, but it wouldn't be particularly relevant. It would be something that the prosecution would object to being admitted into evidence, because it really shouldn't matter what the background is. It would be the facts, the evidence that's presented, and it could come into play as far as was it reasonable for the officer to believe that he needed to use this force, depending on what the defendant was doing at that moment. But, it probably would help just from a visceral perspective, like you said, when it comes to the jury thinking that the defendant was, or rather the victim, was at fault here.
Right. And, of course, we live in a day and age now where we have cell phones and videos and all sorts of things that can belie the actual statements of these officers when they're giving them. Guys, it's been a fascinating case. Thank you very much for the excellent legal analysis. It is really great to be back here at the Law&Crime Network. Thank you for all your chatters that are in there welcoming me back. We're going to take a quick break. Don't go anywhere. We'll be back with more Law&Crime. There's the defense closing argument. We're going to listen to a little bit more of that. I just real quick want to get you guys' opinion, because I think Bones asked a really great question. When you have 6 jurors versus 12 jurors, is it going to make it any faster, any easier, any longer, any shorter? What do you think?
I would think it would be faster. I mean, because you're winning over the minds of 12 individuals, it's going to take a longer time if there's someone who's holding out, there's differing opinions, and sometimes you have the jury out there, and here in New York, you'll get an Allen charge from the judge if the jury seems to be in a deadlock and can't come to a consensus, where the judge essentially sends the jury back in, says, listen, go work with each other, try to reach a verdict, and then you have something called a hard Allen, where if they still can't render a verdict, the judge will send them back in to, again, work together to try to render a verdict. So that's with 12 jurors. Here you have 6. I would imagine just by the math, you may have an easier time for a jury to come to a consensus on a case like this.
What do you think about that, Jennifer?
I agree that you're less likely to have a deadlock when you only have 6 jurors versus 12. And there's also greater diversity typically with 12 people in terms of gender and race, and that could create more divisiveness. I also think that in terms of the evidence, you're more likely to have more evidence being presented with 12 people. The idea that 2 heads are better than 1, or 12 heads are better than 6. And so that could also make things take a little bit longer.
Well, do you guys, just following up on that, do you feel that this 6-jury panel versus 12 favors the prosecution or the defense? I know I'm throwing it at you. It's rough.
Yeah.
Both ways.
Exactly.
Yeah, to me as a defense lawyer, I want to have as many people on that jury, because I would say you try the case to 1 juror at a minimum to get a hung jury. And to your point, Jennifer, many times if you have multiple people, multiple backgrounds, there's more of a chance I can get that 1 juror with 12 than I can with 6. To me, maybe we should do a statistical analysis to find it out.
I think statistics show that it's easier to get a conviction at trial than acquittal. So if you're a defense attorney, like you say, you want as many minds in there because you're drumming up reasonable doubt. And if you drum up reasonable doubt in just 1 mind, there you go.
Well, okay, so let me I'm sorry, I didn't go to spin off on this so much, but let me ask you, is it fair to the defendants in states where they allow 6 jurors to be perhaps more easily convicted for the same kind of offense where there's 12 jurors in other states? I mean, we try to have balance, we have to have truth. Justice is supposed to be equal across the board as best as we humanly can. Isn't it kind of fixing the odds against the defendants in those cases then?
Again, you look at it both ways, right? It could be a benefit to the defense, or it could be a hindrance to the defense and a boon to the prosecution. I mean, it really depends on the case.
Okay, we're going to go to one more clip of the defense closing, and I'll be back on the other round with my great guests. Let's take a listen.
That's where the body is. This is where the shots are. This whole theory about attempted murder, when you apply it to the facts in the case, it doesn't work. When you apply it to the facts in the case, there's obviously no attempted murder. What there is Corey Jones aiming a gun, which we now know is loaded. He didn't know it was loaded or half loaded or safety on. He just knew that a gun, a silver handgun, was pointed at his head, and that he turned as if to fire here, and he turned as if to fire here, and he fired all 6 shots before Corey Jones ever reached the sign, let alone out there. Now, I'm not sure if there was some implication during Dr. Just's testimony and the examination by Miss Ellis, but there is no evidence that Corey Jones was running and got shot in the arm as he was running. No, the shots were all fired while Corey Jones still had the gun, and it was all over way before he got out here. It was all over by the time he was at the sign and dropped the gun. The shots were not fired before the gun was dropped. We know that. The shots were fired after he turned for the second time, aimed his gun at Nouman Raja, fired, he fell down, something silver fell, and he ran off into the distance.
Okay, welcome back. So, okay, guys, I'll start with you, Jennifer. Is the defense scoring points here with this closing statement?
I think when it comes to the attempted first-degree murder, I think he's raising some reasonable doubt when it comes to when the shots were fired, when the gun was dropped. But I think at the outset, though, it's really tough to raise reasonable doubt when it comes to this manslaughter argument, because it looks like this defendant provoked this situation. He created the situation by acting recklessly, by arriving at this scene, not identifying himself as a police officer, getting out of the car and acting in the way he did.
I think we'll all agree with that. Real quick, because we have a short period of time, the alternates have been separated from the jury. Guys, have you ever experienced this phenomenon, and I have over and over again, where the jury comes back with a verdict and the alternates are in shock? They thought it was going to be something completely the other way. Have you ever experienced that?
Yes. Yeah. You know, I always like to speak to the jury after a verdict, whether it be on a civil case or a criminal case. And I like when the judge keeps the alternates there. Sometimes, you know, at the end of a case, the judge will dismiss the alternates. I like when they keep them there and they have them available through verdict. And I like to speak to them. And I have had that where I've spoke to an alternate, and they were telling me that they would have gone a totally different way.
Yeah, Jennifer, I think it kind of goes to a point you made before, that when you have the collective minds of many people deliberating and doing what they do in that jury room, it is a dramatically different thing than when you first go into the jury room with a preconceived idea in your mind where you're going. What do you think?
Sure, yeah. When you have 12 folks in there versus 6, you're going to have more people with more diverse opinions. You'll have more people's notes, more people's theories. And that, I think, essentially, I mean, I think it can cut both ways. But essentially, it can, I think, more likely result in a deadlock.
Yeah, and I think it also speaks to the fact that you may have your own personal opinion, but you can be easily persuaded by the crowd. You could be easily persuaded by the thoughts and ideas of other people and come to a consensus. And again, I've probably had that in 70% of the cases, the alternates thinking it was something different. But listen, guys, unfortunately, from what I understand, Jennifer, you were only on for such a short period of time with me, and you have to go. But I want to thank you so much, as always, for your awesome commentary. We'll see you soon.
Thanks for having me, Bob. Okay, take care.
You got it. Hey, guys, we're going to be covering more of this trial, as you know. But as I told you before, we got the R. Kelly. R. Kelly can't make this guy up. This is going to be coming on at 1 o'clock. So we'll take a break right now so we can get to this R. Kelly special coverage coming up on the other end. Stay tuned.